So in subclause 820.211 little d, written out that way, it says, is the applicant holding this? If an applicant doesn't hold a substantive visa, okay, so that's a person who might be on a bridging visa, they might be unlawful, then do they satisfy the Schedule 3 criteria, 3001, 3 and 4? Now, when you look at them, 3 and 4, you can't possibly meet both 3 and 4 because they talk about different time periods. I think 3 is dealing with periods before the 1st of September 1994 and 4 deals with it post 1st of September 1995. So you can't be both. So realistically, it works that can you meet 3001 plus 3 or 3001 and 4? If you look at 3001, it says, have you been, is your visa is expired within 28 days? Probably it's much longer than that. So if you can't meet 3001, then forget Schedule 3 because you're never going to be able to argue it. So there's no point in arguing something you're going to lose, right? Particularly where there's an exception. And the exception is compelling reasons. Okay, let's have a look at what that means. Now, the interesting thing, the most important case to know about in this is a case called Wayne Siller and the Minister. Now, when we're looking at court cases, I'll do a separate video, which we'll put up next week, of tricks and traps and ideas for reading court cases, okay? And we'll throw a few very simple tribunal decisions at you and so you can see how they work, and I'll break them apart and put them back together again so you can see how it all works. Just in terms of what's important to note here is this little V means and. It's not necessarily versus, but reality is that's what happens in the courts. MIBP is the Minister for Immigration and Border Protection. The minister keeps changing their name, not because it's now Minister Burke as compared to Minister Giles. It's the title of the minister keeps changing. 2016, the square brackets are important. FCAFC is Federal Court of Australia Full Court. That means it's on appeal. 32 is the number of the case. 241 FCR 121. That means it was reported in a journal, which is called the Federal Court Reports, and that's the citation if you want to look for it in that one. Either of these citations are okay. It's just that law citations can be really messy. Okay. So, Schedule 1, 28 days, 3001. Okay. There's the 3001 and 3004. Okay, let's have a look at otherwise compelling. Now, how does Wayne Siller work? So Wayne Siller was there. This is an extract from the case. See what I put per Robinson J. J is for the judge. So this is one of the judge's names. And each of these numbers down here are the paragraph numbers in the decision. So the argument that the minister put was the minister said, well, let's have a look at this Schedule 1 requirement. This is not a Schedule 1, it's a Schedule 2 requirement, time of application. And the minister says, at time of application, you have to show what the compelling reasons are. The judges looked at it, remember the separation of powers? The judges interpret the law, and the judges said, no, minister, you're wrong. Now, it must be exciting to be able to say to the minister, you're wrong, but that's the power of the judge. And the judge says, you, minister, are wrong. The law is not what you say it is. This is the law. The law is time of decision for the compelling. Now, that's important because maybe the case has taken 2, 3, 4 years in the process to get to from start to finish. So you're looking at whether the person's circumstances are becoming more and more and more compelling or less and less and less compelling. Okay, you want them to be becoming more compelling. You can't make up the circumstances. You have to work with the cards you're dealt. You have to work with what the facts the clients have. So I talk about this as a bottle of milk or a bottle of wine. A bottle of milk goes off after about a week. That's bad, okay? Bottle of wine supposedly gets better, is what the wine drinkers will tell me, over time. That's the Wayne Siller provision. It gets better. If the compelling gets better and stronger, that is good for the case. And you can look at what the situation is at the end of the day. Maybe there's a child born after 2 years and the child becomes an Australian citizen by being born in Australia to an Australian citizen parent. The other person can say, look, I now have an Australian citizen child. We argue this is compelling. So you have to, this is where this sort of thing comes in. So the situation is that that's where the compelling factors come in. Now, the word in the regulation is just compelling. Policy goes on for pages of what are examples of immigration think are compelling. But remember the pyramid? The pyramid, it says policy is not the law. The regulation is higher than the policy. The regulation is the law. And where the regulation says compelling, where would you find, how would you think, oh, I wonder what that word means in migration law? Anyone got any ideas? What would you do? Where would you look for it? Quick in the chat. Anyone got an idea? Where am I going to find the meaning of compelling?
Hey, Carrie, can you repeat the questions? Like
the definition sections. Okay, that's a good start. Spoiler alert, we're not going to go to the definition sections because it's not there. Okay, so what the judges tell us, Oxford Dictionary, thanks Caroline, doesn't have to be the Oxford, but the judges say if the word is not defined in the Act or the regulations, then use the ordinary dictionary meaning. Okay, now some of you may think dictionary. Oh yeah, I remember that from school. All right. Now I'm a bit old-fashioned, so I've got my concise Oxford sitting on my desk here, which is actually my late father's 1975 edition. You can get a more modern version. It's all online now. But have a look at what the dictionary meaning is, and that's what the courts will look to. You might want to look at different dictionaries for different meanings. Okay. So that's where we get the meaning for compelling. So let's have a look at prospective marriage, because we're running out of time here. Prospective marriage has certain requirements for it. This is the fiance visa, remember? That both people have to be over 18. The applicant has to be offshore. They have to have known each other and met each other face to face since they each turned 18. So I had a case a few years ago where two cousins married. Now, this is not an uncommon tradition in many cultures, and it was an Iraqi family, and they were cousins. First cousins, they wanted to get married. Nothing wrong with that. That's legal in Australia. And the problem was that they hadn't seen each other face to face for like 15 or something years, because one of them had come to live in Australia and the other one had stayed living in Iraq. So literally, the Australian had to go overseas to see his cousin face to face and have evidence of that, and then come back to Australia in order to lodge this application, because they hadn't seen each other face to face. That's literally how it works. You can't do it on Zoom. It doesn't work that way because it says face to face. Normally what you would also then do is file what's called a notice of intention to marry. That's done at the registry office, birth, deaths and marriages in New South Wales. And the celebrant would write, oh, we're going to get the marriage in about 9 months. Normally they do about 9 months in advance. You can always extend that period of time with the celebrant. And they have an intention to live together as spouses, and the sponsorship requirements are met. This is all the requirements. So it's this case of Ukesian says it has to be face-to-face. That's case law. Can't have an online meeting. That doesn't work. You can for spouse. You could marry each other and not have met face-to-face and still be able to meet the married criteria. But for fiancé, the prospective marriage, you have to have met face-to-face. Okay, prospective marriage continued, no impediment. Let's keep going. It is possible to convert a fiancé to a partner. So that because these cases take so long to be looked at, it's possible, say, for example, to lodge the fiancé, and I've done this in a number of cases, and then they go, can we get married now? Because we don't want to have to wait another 6 months. We're desperate to get married. You know, the party's all ready. You know, we booked the hall and the wedding and celebrant and the dancing and all the singing and all the drums and everything. And you go, yeah, okay, righto. So they get married. Inevitably, this is done offshore. And then they have a local marriage certificate. Provided that's legal, then you present that to immigration. Immigration convert the temporary visa application of the prospective marriage into a partner visa application without paying the extra fee that normally we'd have to pay. Okay. Now you can also do that at the tribunal level, and I've done that at the tribunal where a client's fiancé prospective marriage has been refused. whilst the tribunal taking years to look at these cases, they get married, then you go to the tribunal, hey, tribunal, we're married. The tribunal goes, oh, okay, easy decision for the tribunal. They just go, yep, okay, we're not looking at this anymore. Send it back to the department to look for a partner visa. So it's a nice little way of getting the visa fixed from prospective marriage to married and avoid the extra fees that could be involved. How much are those beautiful fees? $9,095 for the main applicant. Secondary applicants who are over 18, 4550, so that could be a child, for example. Under 18, 2280. So do the mathematics yourself. You're sponsoring person number one. They have a child from a former relationship who is now 18, and they have two other children who are under 18. So that's, whoever's quick on the mathematics can work out how much that's going to cost. It's not going to be cheap. Okay, let's just do a quick little mathematical exercise here. 9095 plus, what did I say? 1 under 18 plus 2 under 18, 2280 plus 2280, $18,205. Okay. Now, if you pay by credit card, there's a 1.4% charge on your credit card. Let's do that times 1.4%. That's $254 on top of that. You can do a direct transfer BPay if that's still available. Sometimes it's not available with immigration to avoid the 1.4%. So that's how much you're paying to get in this where there's multiple children. I had one a couple of years ago that was over $20,000. Okay, and this is not pay in installments. You can't say, oh, can I pay like $100 a month? No, you pay it all up front. This is not, there's not an option here. You pay it, you don't pay it, it's not a valid application. There's nothing for immigration to look at. It's easy, okay? So look at Schedule 1. Don't rely on what you did on the case you did last week. Check the regulations again. Make sure that they haven't changed. Don't believe anything clients tell you about their mythical friends who've somehow managed to get a visa in 5 minutes, okay? Never believe it. Because one, these mythical friends are mythical, because when you say, oh, I'd be interested to see that case, can they send me a copy of it? Oh, yeah, I'm not sure I'll be able to get it. All right? So ignore that. This is just lobbying by the parts of the clients. You go, no, don't care what happened to your friend. Not interested. We're going by what the law says. Okay? Ignore what's in the website, even the department's website. You look at what the regulations and the Act say. That's where you get all this information. Don't rely on what someone's got in the website. Is there a statutory bar? Is there a sponsorship problem? Is it married? Section 5F. Is it de facto? Section 5CB. If de facto, is there a 12-month period? Reg 2.03. Is there a registered relationship? Reg 2.03. What evidence is there for the spouse? The 4 factors. Reg 1.15A for the married, 1.09A for the de facto. Are there family unit members included? Is it an onshore, 82801, or is it offshore, 309100? Okay, these are some checklist things. There's all the bits that are fitting together. Make sure that you keep in mind where these regulations all are. De facto is defined. They're not married in a relationship for each other, but they have a mutual commitment to a shared life to the exclusion of all others. The relationship is genuine and continuing. They live together and not apart on a permanent basis. They might be living apart because one of them's living overseas and one of them's living in Australia. That's okay, as long as they're not living apart permanently. They intend to live together. That's the important thing. And they're not related by family. So you can't be someone's child. You can't be someone's sibling. You can't be someone's parent. Those levels of closeness in a relationship are banned in Australian law for marriage purposes for obvious reasons. And married requires that there is a marriage which is valid in Australian law. Now, it's either a marriage in Australia or is it a marriage which would be recognised as valid in Australia? under the Marriage Act, 1961, which is a Commonwealth Act of Parliament. And the Marriage Act says, well, what is the law in that country? Let's think about a couple of things that could be here. Consent is really important. So there's a question on the form, do you consent? Did you consent to this marriage? Okay, because if you're not consenting, then it's not a valid marriage, even if you've got a certificate. Was the person forced or made under duress to get married? Because if they were, then that's not going to be valid either. Is it a foreign marriage? So what happens in countries where multiple marriages are allowed, what's known as polygamy? So we've got examples of that in countries like Afghanistan and Pakistan, for example. Some countries, and some of the Iraqis used to do it, but they don't seem to do it as much anymore. So where there's multiple marriages, inevitably it's married husband with more than one wife, what happens then? Well, the thing is, they can't do a partner application because they're married to all the others. So only the first marriage is allowed to be lodged as a marriage, a partner. So you'd have to separate from all the others and get divorces, preferably from all the others. Now that's not that hard in some countries. What happens if you've got someone who's married and wants to separate from that person overseas and then wants to marry someone else? But in that country, you don't need to get a divorce. You just get married again. Doesn't work in Australia, because in Australia, that's not considered a valid marriage, because when you married, you were already married to someone else. So you've got to get the divorce in between the two marriages. Okay, we've had clients who have gone, I've got a divorce. You go, yeah, but the date of the divorce is after the second marriage. You know, you've got it around the wrong way. It's not a valid application, not valid as a marriage. It might be de facto, but it's not valid as a marriage. Were they in a prohibited relationship? It's rare. Most countries and cultures don't allow people who are too closely related to get married. Obviously, that causes possible problems in terms of children. Was the consent real? If they're living in Australia, was any party under 16? Because that's not going to be valid in Australian law. And these are all important. Now, you could have a proxy marriage, and I've had clients who do that. A proxy marriage is where someone else stands in for the person, but they say, I represent Fred in this, and the marriage certificate is issued in the correct name, sort of thing. So sometimes this happens in some cultures.